my name is Jane McElligott. I'm here with another installment for our YouTube channel for the Legal Support and Services at Purdue University Global. This case is the Loper Bright Enterprises versus Raimondo case, and it has to do with phishing, but it has much more implications than that. In that it overturns what has become known as Chevron deference or the Chevron doctrine, which has been in the law for 40 years. So this is quite as Justice Kagan said in her dissent, this is a jolt to the legal system. So let's take a look at this case. So a little bit about the facts. So this case was brought by groups of commercial fishermen in New Jersey who were challenging the authority of the federal agency, the National Marine Fisheries Service, to require fishing boats to pay the fee for monitors. So the National Oceanic and Atmospheric Administration, NOAA, requires monitors to go aboard the ships to make sure that the fishermen are complying with the limits to prevent overfishing, because of course the consequences of that, not only could the species, this was herring fishing, but there has been a substantial loss in the number of herring. It could also impact seabirds that feed on the herring. It can have major consequences for wildlife, for fish, for the environment as a whole. So the federal agency has required the ships themselves to pay the fee because just the cost would be kind of unmanageable for the agency to cover. And it is thought that it is, an important enough goal to require such a fee. So this challenge did not go very far at first. So the U.S. District Court, which is the federal trial court, and the U.S. Court of Appeals both applied what's called the Chevron doctrine that we'll look at in a second. And they upheld the federal agencies, the National Marine Fisheries Service agency's interpretation of the federal law and its requirement that the fishing boat pays the fee as reasonable. So ruled in favor of the agency, giving that deference to the agency. The fishermen, though, were not happy with that decision. They petitioned SCOTUS, Supreme Court of the United States, and asked the court to weigh in on this rule, kind of give their own decision on this rule, and also to dismantle the Chevron doctrine. So it was really a planned attempt to try to bring down the Chevron doctrine. SCOTUS did grant cert, and the Chevron doctrine was on the line, so to speak. So what is the Chevron doctrine all about? So again, this is a 40-year-old doctrine, so it has been enmeshed in the law, and it comes from this case called Chevron versus National Resource Defense Council. A 1984 case where SCOTUS held that the meaning of a federal statute, so for example, say a provision in the Environmental Protection Act, if that is ambiguous, then the court should defer to the relevant federal administrative agency's interpretation of the statute, which would be the Environmental Protection Agency, with the thought that Environmental Protection Agency is packed with scientists, with experts who know how to best interpret the meaning of any ambiguous terms in that statute. So looking at the evidence, at science, what is best, or in this particular case, what is best to manage fish so that for conservation, for environmental concerns. The thought is that those who, their whole lives are focused on this issue would be better off deciding that than judges who may not really know much about the issue at all. Judges, hear all kinds of cases. They're not going to be experts in every particular issue. So as you can see here from this chart, this shows what's called the Chevron two-step process. So if the law is ambiguous, and this is all federal law, so if a federal law is ambiguous, meaning that, it could be open to a couple of interpretations, then if the agency agency's interpretation is reasonable, and that just means, it's rational. There's nothing, it's not inconsistent with the overall statute. It's not capricious, for example. As long as that's reasonable, then the court will accept the agency's interpretation. If it's not reasonable, which really doesn't happen too often, then it's up to the court to interpret it. If the law if it's not ambiguous, so if the law is clear, then that's the end of it. The court just follows the law. That's easy. So it's only when the law is open to interpretation that it then is deferred to the federal agency. So as it says down here, so that again, if the meaning of the federal statute is clear, then the court just follows that meaning. If the meaning is ambiguous, then the court goes through this two-step. But it does make, looking at this, it really does make sense, because you have agencies, again, the EPA, the FDA, the EEOC, these are all experts, whether it be in science or, public health or in employment law. They know how to interpret these provisions the best. So SCOTUS ended up, as pictured there, threw the Chevron doctrine overboard and upended 40 years of precedent. So, and really, Chevron had become, by this point, over the 40 years, the most important ruling on federal administrative law, having been cited by federal courts more than 18,000 times. So the lower federal courts were relying on this, making decisions left and right based on this decision. And then all of a sudden, it's just gone. It's thrown overboard. And Justice Kagan, in her dissent, said Chevron is as embedded gets in the law. So really emphasizing that this is a major precedent that the court just tossed. And so in an attempt to justify the sea change, I couldn't resist there, in the law, Chief Justice Roberts, he wrote the majority opinion. And again, this is 6-3, so it was all the 6 more conservative justices and the 3 more liberal justices, Kagan, Sotomayor, and Jackson, going for the dissent. But he asserted that the Administrative Procedure Act, which governs administrative law, requires courts, not administrative agencies, to exercise independent judgment in deciding whether an agency acted within its statutory authority. And he labeled Chevron as a judicial invention that allowed judges to disregard their duties to interpret statutes. So he gave this view that Chevron was wrongly decided because it's just kind of taking away a power that judges should have had all along. Justice Kagan, though, gives us a whole other side of that. And I think this speaks to the importance too of reading both the majority and the dissenting opinions, because sometimes you can read the majority and it sounds okay, and then when you read the dissent, it makes you really look at it again. So Kagan, again, just joined by Justices Sotomayor and Jackson, wrote an extremely powerful dissent, and in doing so, she also mapped out the alarming likely consequences of the majority's decision. And she really referred to the court's decision to say, oh no, it's judges that make these decisions, not administrative agencies, as a power grab. And she wrote, in one fell swoop, the majority today gives itself exclusive power over every open issue, no matter how expertise-driven or policy-laden, involving the meaning of regulatory law. The majority turns itself into the country's administrative czar. So very strong language there. She went back and quoted a line from the Chevron decision in 1984, where the court said judges are not experts in the field and are not part of either political branch. So back then, And then she says those were the days when we knew that what we were, meaning as judges, and what we are not. And we recognize that agencies are experts in the field. So back in 1984, the judges recognized that, hey, these are the ones who know this the best. Let them decide when there's a question in the law. And keep in mind too that oftentimes, when Congress passes an act or a statute, oftentimes intentionally they leave it a little bit open, or not necessarily vague, but a little open to interpretation, so that as time goes along, it gives leeway to the administrative agency to kind of run with it as best as it works best. So this happens in quite a few instances or it has happened in the past, that an agency's interpretation is needed. Kagan also emphasized how Chevron deference to federal agencies has worked so effectively over the years. And as she said, the language is really good. It has become the warp and woof of modern government, supporting regulatory efforts of all kinds. To name a few, keeping air and water clean, food and drug safe, financial markets honest. So this decision really reaches an enormous span of topics, of issues. And again, that's what she referred to it as the jolt to the legal system caused by SCOTUS in this case is no less than a recipe for chaos. And this is a expert's opinion from one of the environmental organizations, was saying that instead of having the agencies with their expertise, we're going to have hundreds of federal judges, spread out throughout the country, who lack the expertise of agency personnel, who are going to be reaching inconsistent results. It's going to be a mess. And these are very complex technical issues. And what could happen is these judges, in cases where, say, corporate industries, big oil wants to get a ruling in their favor, they can pile into the court all of these studies that have done by the industry that are very, very favorable to the industry. Much of the material that's submitted by the court is not going to be reviewed with the more keen eye of, say, a scientist or other type of expert in the field. So this is going to place at risk really public health, the environment at a time when we're in the midst really of a climate crisis, wildlife that are currently safeguarded under Endangered Species Act. Now judges are going to decide what type of wildlife deserve safeguards, or which ones are able to, not get any more safeguards anymore. It's really concerning, the implications of this decision, and we'll have to see as time goes on. But there is a lot of concern as to what can happen. And I think this quote is a very fitting one, that if you really think the environment is less important than economy, try holding your breath while you count your money. And it seems as though this has been an enormous win for corporations and big oil and the companies who may value money over the environment and public health. So I leave you with, there's some resources on that. As always, SCOTUS blog has a great article on this. There's a very good article there from Harvard Law School Forum on Corporate Governance on the implications of what this case could lead to. And I love that the title of this one, "The Supreme Court Threw Us Overboard and the Chevron Deference with its fish ruling." And the interesting thing is, even though this case started out talking about fish, the court hardly even addressed the fish question at all. So that has gone back to the lower court for the lower courts to decide, what to do. So some judge is going to decide, should that burden be on the boats or on the agency. The interesting thing is the agency actually stopped charging the $700. They don't really have many monitors going on boats anymore at all. So that the issue was kind of really, it almost was moot and probably could have been dismissed on those grounds. But clearly, this is something the Supreme Court wanted to take and run with, and they did. So that is it for now, but I hope to I will see you at the next SCOTUS video. Thank you.